Okay, as Lainey begins to bark, right as I'm starting this video, I want to talk more substantively. Now, I've been posting videos about how to spot certain issues, right? Particularly Article 3 issues. But now I want to talk just for a few minutes about the checklist of substantively what you need to know, right, in order to resolve one of those issues. It's one thing to spot it; it's another thing to know, right, how to resolve it. So, very quickly, want to run through, and this video will run through at least the first 6. We'll see how this goes, but there are other issues related to judicial branch in Article 3, and you can see the relationship here. But we're talking here about courts. What cases should courts hear? What cases are courts allowed to hear? Right? What power do courts have? What are the limits on the power of courts? So, then of course, that's how we started this this term. Right? It's talking about judicial power under Article 3. So, what do you need to know? One, obviously, you need to know judicial review. I talked about in another video how that's tested. But of course, you know, your understanding of that term and that principle has to reflect, right, an understanding that judicial review belongs to all federal courts, right, district, circuit, and the Supreme Court. All of them have the power of judicial review, which is the power to declare a law or policy, right, void under the Constitution in relation to the case in front of that court. And as we've talked about before, you know, a district judge only binds the parties to the case, but if one of the parties to the case is the United States of America, then a district court's order binds, right, binds the United States. So there is where that power where the issue of a stay becomes very important, right? You look at a federal court order from any federal court that does not have a stay on it. If it's a judgment and order, it has to be obeyed immediately. Oftentimes there will be a stay on it. That you are to distinguish, and we're moving to Roman numeral 2, between judicial review and judicial supremacy. So these are ideas that, as we go through these, you should be asking yourself, do I understand this fully well? Do I understand this so well I could explain it, right? I could explain it to my dog, I could explain it to my kids, I could explain it to my spouse in a way they could understand it. Well, maybe not the dog. But so that's what we're talking about here. Judicial supremacy, you immediately should be able to say, okay, that's different than judicial review, because judicial review belongs to all federal courts. Judicial supremacy only belongs to the Supreme Court. And what is it? It is the power of the Supreme Court when it decides a federal question to bind all state actors, not just courts, all state actors throughout the United States. Roman numeral 3, jurisdiction. Okay, this is something that under Article 3 you need to know. I need to be very clear about the jurisdiction in Article 3, right, of the Supreme Court, and you also need to be comfortable with, right, Congress's role in setting the jurisdiction of federal courts. So you know that in very limited circumstances, the Supreme Court has original jurisdiction. Now, we've talked about that repeatedly, how to spot, right, original jurisdiction, and when it's happening in a fact pattern, right, when Congress expands the original jurisdiction of the Supreme Court, you need to be able to see that. So the original jurisdiction of the Supreme Court extends only to cases involving ambassadors, consuls, right, and states as parties. Other than that, in all other cases, the Supreme Court has only appellate jurisdiction. Now, it is up to Congress, right, to delineate the appellate jurisdiction of the Supreme Court, because that's what Article 3 says, right? Under such exceptions and with such regulations, right, as Congress shall make. So Congress can regulate the appellate jurisdiction of the Supreme Court. It may not expand the original jurisdiction of the Supreme Court. That brings us to the rule from Ex parte McCardle, right, and also the rule from Klein. Congress can remove the Supreme Court's appellate jurisdiction to hear a certain class of cases anytime before the Supreme Court issues an order, right, an opinion on one of those issues or one of those classes of cases. But the limits of that were expressed in the Klein case, right, where the court basically said two things. And again, when I say Klein, you should be able to come back at me really fast, right? Oh, Klein stands for what proposition? One, you're supposed to be targeting future cases when you take away, right, when you exercise your jurisdiction stripping power and take away our jurisdiction. It should be to stop us from deciding a case, not because you're mad about a case we already decided, right? And second of all, and remember this, right? The Congress does not have any business, right, or authority telling courts how to decide cases, which means they also shouldn't be taking away court jurisdiction, because they don't like how the court decided a case. Not that it decided it, but how it decided it. So when Congress is, first of all, targeting a past decision that a court already made, right? Or it's passes a jurisdiction stripping law because it's not happy with how a court decided a case, those would not be valid bases for jurisdiction stripping. That is the rule of Klein. So all that falls under jurisdiction, as well as the authority of Congress, and you need to know this, right, to regulate the jurisdiction, both original and appellate, of lower federal courts, those being federal circuit courts and federal district courts. Okay, next, political question doctrine. Again, there is a video out already about how to spot that, but the rules, right, you know the rules. You should be able to rattle these off, no problem. Right, there are 3 categories of political questions. There is those that are textually committed, right, to a coordinate branch of government. That requires you to know or be roughly familiar, right, with the text of the Constitution, so you know when something is textually committed to another part of the government, another branch of the government. So that's one category. Category 2 is lack judicially discoverable and manageable standards. That's a lot of syllables for a simple idea that it may be a question, but it's not a legal question. And the third category of political question is prudential, prudential considerations, where a court, to avoid embarrassment or to avoid causing a mess, would decline to get involved in usually some kind of conflict between the other 2 branches, right, the executive and the legislative. Next, standing. Okay, so I've also posted a video about that, how to tell that you're being tested on standing. But what are the rules of standing? This is pretty straightforward stuff, right? Because it's elemental, right? There are 3 elements to standing: injury in fact, concrete, palpable injury, right? Not conjectural, not speculative, not theoretical, not hurt feelings, right? That kind of thing. So that's the first element. The second element is causation. You'd have to show that the injury that's present there, the concrete injury, was caused by whichever governmental entity is being sued, right? Because it's a constitutional case. And then finally, you have to have redressability, right? Which means that there's something the court can do about it, right? That the court can issue some kind of a remedy. Related to standing, obviously, is mootness and ripeness, right? Ripeness related to injury in fact, right? That the injury has already happened, and it's concrete, or at least it's imminently threatened. And on the other side, redressability relates to mootness, right? Because if the case is mooted out, then there's nothing the court can do about it anymore. So you need to be familiar with those. You need to be familiar with the exception, right? With regard to cases where the issue is capable of repetition yet avoiding review. And you also need to be familiar with the taxpayer standing rules, which I covered in the issue spotting video, so I'm not going to do that again. But that's standing. You need to substantively be very comfortable with the standing issue and how to run through an analysis of standing. Finally, as to the really direct issues directly related to Article 3 and court power and jurisdiction, you have to be aware of these issues, right? The rule of 4, that's related to certiorari, that it takes 4 justices to agree to grant cert. Rule 10, which gives you the 3 circumstances under which cert is most likely to be granted. And that includes a circuit split, a split among the states, or an important federal question that calls out for immediate resolution. Also need to be familiar with the idea of adequate and independent state grounds, right? Which is sort of a minor topic in constitutional law, but is heavily tested on the bar exam for whatever reason. This is to say that if you're talking about cases, and this involves jurisdiction as well, so that's up at Roman numeral 3. The Supreme Court does have appellate jurisdiction to hear cases coming out of the highest court in a state, right? If it's a final judgment from the highest court in the state on a federal question. As to that last part, if the state court decision rests on state law, even if it's partially based on state law, right? I'm sorry, on federal law, if the state law part of the decision would resolve the case, right? No matter what the court had said on the federal question. If the highest court in a state has based its decision on state law, and the state law would, the state law decision would cause the result in the case, no matter what the court said about the state law. the federal law question, then that is adequate and independent state grounds. So you have to look when there's a case coming up from the Supreme Court of a state, it's going on appeal to the U.S. Supreme Court, you have to look what was the basis of the state court's decision. If the decision rests on state grounds, that's adequate and independent state grounds. If the decision rests on federal law, right, then obviously the Supreme Court can hear that because it's not adequate and independent state grounds. Okay, I think that'll do it for this one video. Because the Roman numeral 7, 8, and 9 here that are related issues, kind of more procedural issues, will take a little more time. I don't want to run out of time on this video, but that gets you started, right? We'll also do videos on Article 1 and Article 2 and joint Congress and all that stuff under state power. But I want you to have these checklists in mind as we go over the review questions, right, when we do our live session. So there's Roman numerals 1 through 6. Those should be topics. That should be subject matter that you're very comfortable with now. If you are, good. So until the next video, stay safe and stay tuned and be well.